U.S. prosecutors want FTX founder Sam Bankman-Fried to spend the remainder of his time in jail ahead of his criminal trial. Joining us now to discuss is CoinDesk Global Policy and Regulation Managing Editor Nick Day, who's also the editor of CoinDesk's State of Crypto newsletter. Good morning, Nick.
Good morning.
How are you doing this morning?
I'm good. I am certainly in, I think, better shape than Mr. Bankman-Fried.
I think we all are. So the Department of Justice is alleging that he's tried multiple times to tamper with witnesses. Talk to me about what the DOJ is saying here and what they want to happen.
Yeah, so yesterday there was a hearing in the courthouse in Manhattan where the DOJ opened up and said, we were seeking detention for Sam Bankman-Fried. So the DOJ alleged last week that he shared Carolyn Ellison, the former Alameda Research CEO and one-time romantic partner of Bankman-Fried, with the New York Times, basically in an effort to discredit her as a witness or a possible witness in court when his criminal trial starts in October. The DOJ says this isn't the first time. They pointed to the fact that Bankman-Fried had previously reached out to Ryan Miller, the former FTX US general counsel, in what the DOJ says was also an effort to try and basically influence his testimony, something the judge agreed with. And now they want to, remand him to jail for the remainder of the time prior to his trials beginning. They're saying there's no set of release conditions that they believe would protect the public interest or general public. And so, yeah, that's where they're at.
How are Bankman-Fried's lawyers responding to this?
Well, they're obviously disputing the characterization of the letter. They say that, Bankman-Fried wasn't trying to discredit a witness or, influence testimony, but their position is that there have been, quote, over 1 million negative articles about Bankman-Fried and literally thousands of, about him and Ellison. So their view or their position is that Bankman-Fried has a First Amendment right to, make a fair comment, to basically, defend himself and try and, clean up his reputation. So they're saying that they would agree to, and what they expected was, a kind of a blanket gag order preventing anyone in the case from speaking to the media or, making utter public comments. But they think that detention is A, going too far, and B, they say it would make it more difficult to organize Bankman-Fried's defense because so many documents are only accessible through online tools and online, systems.
So what could happen next year if he is restricted from communicating publicly?
So to be clear, the judge did order an interim gag order, basically preventing any kind of public comment. But kind of, the more, I think, serious thing for Bankman-Fried and his team, the judge has given the prosecution until tomorrow to basically lay out a case for why they believe he should be remanded into custody. The defense has until Tuesday to respond, and then the prosecution can make one more, written submission by the end of next Thursday, saying, okay, here's what our response is to the defense response. So it sure seems like we are headed to a position where the judge is either going to order another hearing or otherwise, review just the written submissions and say, okay, well, either A, Mr. Bankman-Fried is going to have to spend the remainder of the time before trial in prison, or B, he might decide, okay, well, the gag order is sufficient and XYZ. But it is worth noting he did end yesterday's hearing by, quite directly speaking to Bankman-Fried, warning him to, quote, take the matter seriously.
Nick, I think we should just change the name of this segment to Sam Bankman-Fried Watch. We could have some kind of sensational intro. It would be very suiting. The last question I have for you here is about this campaign finance charge that was dropped by the DOJ. Why did we see that dropped?
Yeah, so this actually, we're going to get a little bit into like the procedural stuff here. So of course, Bankman-Fried was arrested in the Bahamas last year and extradited to the U.S. As part of that, the Bahamas had a document with the list of proposed charges, and they had to functionally agree to those charges before extradition. Now, Bankman-Fried had previously argued that certain charges that the DOJ brought in superseding indictments, meaning they brought them after his extradition and arrest in the U.S., that they shouldn't be tried on those charges because the Bahamas had not agreed to them. And the judge at the time said, okay, we'll schedule a separate trial for March 2024 and give the Bahamas a chance to weigh in on these additional charges and, basically sort out all of the extradition treaty issues. Last night, the U.S. Department of Justice said that they had consulted with Bahamas and found that the campaign finance charge, which they originally said was part of the first 8 charges that they had extradited him on, was not actually part of the extradition document that the Bahamas had. And so they need the Bahamas permission basically to charge him on that. The implication is that this campaign finance charge may come up in the March 2024 trial now instead of the October 2023 trial. They didn't say that, but based on how they treated the other charges that they severed and moved into March 2024, that does kind of seem to be the I would say the implicit understanding a lot of people would have as to how that might be treated. But of course, we're still waiting on the DOJ to confirm that one way or another.
All right, Nick, thanks for joining us this morning and laying out the details there.